Welcome tonight to Meet the Researchers talk. This series was started a few years ago to give the opportunity for the research staff to present their work as they're going through it, and also perhaps when they're coming towards the end of it, but also to give our supporters and friends a chance to hear them present their ideas, and also to perhaps give us some good feedback, because any organisation like this does need to hear from the public about some of these things. So that's why the series was started, and it's been running mostly monthly ever since. Tonight's topic, of course, is a very contentious one, and namely industrial relations reform. It was one of the issues that saw the Howard government depart from office in 2007, and of course since then the various forms of the Labor government has made a number of changes, and the Fair Work Act is the main focus of that. And that's the topic to which our young researcher, Alex Philipatos, will be discussing tonight. How much fact and fiction lies behind the claim that we're back to the bad old days of the IR Club? Alex joined CIS in April last year. He's an honours degree in economics from La Trobe University in Melbourne, and then published in his first paper for us, and it's a very good one, was on why why Sydney Ferry should be privatised. Well, of course, the government just went and did it, didn't they? So, sort of privatised. He had some other thoughts as to what they should do, but perhaps that's for the next one, maybe for the buses. Now he's jumped in the deep end with a really big and complex issue of IR, and I would now ask him to give his presentation. Thanks, Alex.
Thanks, Greg. And I'd just like to thank everyone for coming on this cold and rainy night. Last year, Peter Anderson from the Australian Chamber of Commerce and Industry warned about a return to the industrial chaos in the workforce. Just a few months ago, Tony Shepherd from Transfield said Australia was becoming a high-cost, low-productivity nation. And only a few weeks ago, BHP Chairman Jack Nasser said the industrial relations framework pitted labour against capital. And based on these sentiments, one could be forgiven for thinking that industrial relations in Australia is in the throes of a crisis, taking the country back to the pre-reform days of low productivity, inflexible work practices, and high levels of disputes. So have we actually turned back the clock, or is the business community simply exaggerating the situation? To answer these questions, we obviously need to go back to the pre-reform days and study the effects of the changes that began in the 1990s, of which there are four main ones at least. Keating's reforms of 1993, Howard's Workplace Relations Act in 1996, Work Choices in 2005, and now the Fair Work Act, 2009. So my research into this divisive and emotive issue has led me to believe that the story is neither all good nor all bad. There are definitely some problematic areas in the Act, but predictions about the return of the Industrial Relations Club are a little bit misplaced. So tonight I'm going to focus on four broad areas to evaluate the state of industrial relations in Australia. There are two areas that I think are problematic. First, there is a real problem with unfair dismissal laws. Unfair dismissal coverage has broadened and claims have gone up significantly. This is a major issue for small businesses who don't have the same resources as large businesses to cope with the claims. Second, new good faith bargaining obligations have changed the role of unions and the state in workplace matters, and that changes for the worse, in my opinion. There are two positive developments, though. First, the move towards a decentralised, enterprise-based system of wage setting has been successful and positive. And second, the changes to rules around industrial action have had positive results, and the Fair Work Act has largely kept this structure intact. So first up, I'd like to talk about unfair dismissal laws. Unfair dismissal laws first appeared in the 1970s and 80s, and were introduced at the federal level in 1993. Paul Keating's dismissal laws were different from the states in that they carried a reverse onus of proof. So usually the employee has to show that the dismissal was harsh, unjust, or unreasonable. But Keating's reforms forced the employer to show that there was a valid reason for dismissal. Howard's Workplace Relations Act, the one in 1996, put the onus back onto the employee. Then in 2005, the work choices amendments exempted businesses with fewer than 100 employees from claims, and also created a protection for larger businesses to dismiss for genuine operational reasons. Now, as we well know, this didn't go down too well. The ACTU's Your Rights at Work campaign helped Labor back into office in 2007 on the promise of tearing up work choices. And the Labor government then introduced the Fair Work Act, and now businesses can no longer sack workers for genuine operational reasons, and the exemption on businesses with fewer than 100 employees has been scrapped. Now, there is a provision for businesses with 15 employees or less. It's called the Fair Dismissal Code, but a close look at the code reveals that the protections for small businesses are rather piecemeal. Since the Fair Work legislation was enacted in 2009, claims lodged to Fair Work Australia have more than doubled, from roughly 8,000 to almost 17,000. Now, there are two reasons for this remarkable surge. First, small businesses are no longer exempt from unfair dismissal, as I said, and that means that a lot more businesses are susceptible to claims. And the second is a jurisdiction thing. The Fair Work Act covers all workers in the private sector except for Western Australia. This means that instead of claims being lodged to the state commissions, they're lodged to Fair Work Australia. And so this sort of pushes the data up. So what does the large rise in unfair dismissals mean? To answer that, I want to have a look at some figures. In this graph here, we've got the unfair dismissal outcomes from 1997 to 98, all the way to more or less current. The blue line up the top represents the proportion of claims, the percentage, that are settled at conciliation. And conciliation is obviously the most important because it's upwards of 80% are conciliated. The green line down the bottom, a very small percentage, represents the proportion of claims that go all the way to arbitration. And the red line represents those that proceed past conciliation but stop before arbitration. So what is conciliation? Conciliation is a negotiation where the employer, employee, and an officer from Fair Work Australia come to an agreement. It's not like a court appearance where you give evidence, argue your point, and then get scrutinised. So negotiation is a good thing, right? Well, actually, I don't think it is. Conciliation brings with it issues that need scrutiny. Now, Grace Collier has written an excellent chapter in Gary John's book, Right Social Justice, that illustrates these issues. And since I can't improve on her work, I'm going to quote from the book, from her chapter. So Collier says, and I'm quoting, "An employment separation can occur in three ways. A person can resign, be dismissed, or made redundant. Under the current legislation, someone can resign their job and claim unfair dismissal. Someone can be made redundant, accept a redundancy package, and then claim for unfair dismissal. And someone can be sacked and claim unfair dismissal." So those are the three ways. Now, anyone can go onto the Fair Work Australia website, pay $60 to fill out a 2 or 3 page claim, and once you've lodged it, a conciliation is set up. Now, the conciliator, as Collier says, usually begins by saying something along these lines, and I'm quoting again from her book, from her chapter. "Today is not about who is right and who is wrong. I will hear the parties speak, but no evidence is to be put forward, as this stage is not about making judgments. It's about helping the parties settle the matter to avoid litigation." Now, Collier goes on to say, "The stories of the parties vary significantly, and the conciliator usually very quickly comes to the point where they're saying something like, 'You were saying one thing and you were saying another. I have no idea where the truth lies.' The point is that if this matter is not settled today, the employer will bear the cost of an expensive trial that could cost upwards of $30,000. I'm trying to assist you to avoid that situation. So as the employer, how much are you willing to pay to settle this matter today?" And with that, the pressure upon the employer to pay go-away money begins. Now, the fact that this system applies such pressure at even one conference is frankly deplorable. And the fact that the conciliator doesn't introduce facts or challenge the claims of either party is unacceptable. I think it goes against the principle of fairness. If this is the common process of conciliation, then unfair dismissal is essentially a scam, a means by which one party blackmails the other into a payout. So, do we really need dismissal provisions at all, unfair dismissal provisions? what happens to workers who find themselves in financial difficulty after they've been sacked? Well, in my opinion, we already have a system in place for workers who are put into financial difficulty, and that's our unemployment benefits. Now, if you're on a low enough income that you're put into financial stress, that's what they're there to provide. So, in my opinion, you can either have unfair dismissal provisions or unemployment benefits, but not both. I just want to make things clear, though. Abolishing unfair dismissal does not mean employees are without protection. There are still provisions under common law and statute that guarantee due process and protect employees against dismissal from discrimination. There is also some protection at common law for harsh, unjust, or unreasonable dismissals. But I think the system that we have today is broken. I think the unfair dismissal process is a farcical exercise of bluff and blackmail. The other thing to remember is that 20% of the workforce is casual, and there's no secret that employers have workers employed under full-time or part-time conditions, but they're nominally casual, so that the employer can avoid claims for unfair dismissal. Now, these workers don't have sick leave, annual leave, or the other entitlements that permanent workers get. So in the absence of unfair dismissal laws, it would simply make sense for many employers, to offer these casuals full-time or part-time positions. At least this way, they would have the same rights and entitlements as everyone else. So next I want to get on to good faith bargaining. Good faith bargaining is a relatively new concept, at least in Australia. It exists in New Zealand, in Canada, and the US. It wasn't part of work choices in 2005 or Howard's original legislation in 96. Good faith bargaining is a very important part of the Fair Work Act because it alters the balance of power between employers and unions and allows wider scope for the state, via Fair Work Australia, to intervene in the workplace. Under the new good faith bargaining rules, bargaining can begin in three ways. The first, the employer can initiate bargaining. Second, the employer and the union can agree to bargain. And third, if the employer refuses to bargain and the union has support of a majority of workers, then the union can obtain what's called a majority support determination from Fair Work Australia. And what this does is essentially forces the employer to bargain with the union. Now, once begun, the process of bargaining is incredibly formal and over-regulated. The employer has to notify employees in the prescribed format about their right to employ a bargaining representative, most likely a union, and they must bargain in good faith. So what does that actually mean to bargain in good faith? Well, employers don't necessarily have to come to an agreement with the union, but they have to make sure that they attend and participate meetings at reasonable times. They have to respond to proposals and disclose information in a timely manner. They have to genuinely consider proposals and provide reasons for their responses. Fourth, they have to refrain from capricious or unfair conduct that undermines freedom of association and collective bargaining. And five, recognise and bargain with the other representative. So there's a lot there that they have to do or not do. So if employers do not follow these good faith bargaining obligations, they face bargaining orders from Fair Work Australia, as well as fines of up to $30,000 per breach. Now, in some circumstances, Fair Work Australia may even arbitrate the entire agreement. So as we can see, the obligations are there to regulate the conduct of an employer who didn't wish to bargain with the union in the first place. What it means is that employers can no longer offer the terms of work as a take it or leave it offer. Under the new system, union recognition and collective bargaining are given a special place in the Act at the expense of freedom of contract and managerial prerogative. The Workplace Relations Act and work choices contain no obligation to bargain in good faith. Instead, they gave greater respect to freedom of contract. A union had the right to represent employees, but it could not bargain with an employer without their consent. Under Howard's reforms, it was understood that businesses ought to have the right or the freedom to set the conditions and relationships of their own workforce. This was particularly important for the behaviour of unions because it meant that their place at the bargaining table was not guaranteed, and therefore they could not necessarily throw their weight around. under Howard's reforms, it was understood that... sorry, I've done that. I want to move on to another subject, one of the more positive stories of industrial reform. Before the introduction of enterprise bargaining, much of the workforce was regulated by industrial awards. Of all the positive changes to our industrial relations system, the move towards a flexible, enterprise-based system has been, in my opinion, the most significant and the most successful. In 1990, almost half of the Australian workforce had their pay and conditions set by awards. By 2000, this was down to 23%, and today it's just over 15%. So I want to go through some statistics on the Australian workforce. These figures here show how the workforce had their pay and conditions regulated in 2008. Now, the figures are released every 2 years, so they are out for 2010, but for some reason, here where you see registered collective agreements and unregistered collective agreements, and registered individual and unregistered individual, you don't have this registered and unregistered, they're pulled into one. So I'm not sure why the government's done this, but in any case, the data's not informative, so I'm using the 2008 statistics. Alright, so you can see that individual agreements and collective agreements, the unregistered agreements have been around since before the reform era, along with awards. The popular individual agreements in the private sector, I've highlighted in yellow, they just operate as common law contracts. Registered agreements were a product of the reform era. Collective agreements were introduced by Paul Keating in 1993, and the individual agreements, the AWAs, the infamous Australian Workplace Agreements, were introduced in 1996 by Howard. What's interesting about this chart is that if you have a look at the little orange bits here, almost 80% of the workforce is regulated by individual or collective agreements. In the public sector, almost the whole workforce is regulated by registered collective agreements. Now, these are usually union agreements, and so it's pretty clear from which form of agreement unions think will are best for their members. Now, looking at those statistics, I think the decentralisation of our industrial relations system has been pretty successful. And I think this is good news for productivity, good news for wage levels, and good news for workplace flexibility. If we have a look at labour market productivity here, I think the results speak for themselves. The most rapid growth in productivity occurred mid to late 90s after the Keating reforms and Howard's 1996 reforms. That's the green bit in the middle. So that's the area where the slope is largest. I think the deregulation of Australia's workplace system was also largely unavoidable. By and large, Australia is no longer a protectionist country. Most of the tariffs and subsidies that used to prop up failing industries have been removed. Businesses now have to be globally competitive. So this means it's not business as usual for unions. They can't expect to extract large pay rises from employers without improvements to productivity and simply shift these costs on to taxpayers with increased subsidies and increased tariffs. Now they have to offer something in return for their demands. And this change has been enormously positive for business, workers and the Australian economy because productivity has increased, wages have grown and the economy has become more competitive. We now have a lot more new industries, particularly the service industries. Now if we have a look at this chart here, we'll see that it's far more profitable as a worker to be on an agreement than on an award. So the first one here, we've got awards, then registered collective agreements, unregistered, and registered individual agreements, and unregistered again. So the red is public, the blue is private, and green, of course, is all sectors. So, not surprisingly as well, average public sector workers are higher than the private sector, and I think that's a little bit of a funny note. On a little side note, I might add that for all the controversy created by Australian workplace agreements, Howard's registered individual agreements, they've been pretty insignificant. If we look back to a previous table, after 10 years, 12 years, only 2.2% of the workforce is regulated by AWAs. And for those who are on AWAs, if we have a look at this fourth column, or fourth lot of columns, those who are on AWAs are actually doing pretty well in terms of their wages. So overall, I think the story here is a pretty positive one. The movement to a more decentralized system has been successful and, in my opinion, irreversible. But there's still some work to be done on awards. I should add, before I mention what should be done, there have been some positive movements in awards from 1993 onwards, and even under the Fair Work Act. Before the reforms, there were literally thousands of awards covering millions of employees. Now there are about 120. They're much less complex than they used to be, regulate a lot less of the employment contract, and contain with them measures for increased flexibility. And now this is positive because if they're supposed to be a safety net, they ought to be few, simple, and easy to understand. Awards aren't without their problems, though. Reducing the number of awards has meant that they become more problematic for some businesses. Penalty rates, minimum shift hours, and shift allowances in the hotel sector, for example, are different to those in the cafe sector. And having one award for both, as they currently do now, simply doesn't make sense. This problem is made worse by Julie Gillard's pledge that no worker will be made worse off by the award modernisation process. This meant that if two awards were combined into one with high entitlements and one with low entitlements, the lower one was brought up to the higher one. So for many small businesses, this cost hike was more than they could afford. Ultimately, I think they need to be replaced with a set of minimum conditions, abolished, I should say, and then replaced with a set of minimum conditions that an enterprise agreement has to conform to, such as the 5 minimum conditions that were set out in work choices. This way, they retain the necessary safety net requirements, and everything else can be tailored to the business's needs. So I want to move to my final topic to discuss tonight. It's industrial action. It's an area that has seen significant change over the past 20 years, and it's an example of what can happen when the government gets it right. So historically, Australian law has not recognised a legal right to strike. The whole point of compulsory arbitration, the Australian experiment, was that you didn't need to strike if you could lodge a claim and get an arbitrated outcome through what would now be called Fair Work Australia. But as we well know, Australia's had its fair share of strikes, even though they were illegal. Employers, governments, and the industrial courts, to some extent, turned a blind eye to it. Now, prolonged strikes were generally rare, and most were short-lived. So, how have industrial disputes changed over the years? If we have a look here, when we're having a look at the incidence of strikes, it's important to control for the relevant factors. Australia's population has increased quite a lot, and if we're going to look at if we're just going to record the number of people who go on strike, the graph would look very different. So this graph shows the changes in the strike rate from 1985 to 2011, measured by the number of working hours lost per 1,000 employees. So it's controlled for the amount of people in the workforce. The red line that I've got going down, that's trade union membership as a percentage of the entire workforce. So there are a few interesting stories about this graph here. And the first is that the long-term trend is down. And that's definitely a good thing. And the second thing that jumps out about this graph is that there are two distinct periods. There's the pre-reform era, before 1993, and then after 1993. In the period before 1993, the average strike rate was 54 working hours lost per 1,000 workers, and that rate got as high as 104 or 105. That's twice the average. Now, in the period after 1993, the average has been just 13 hours. That's a 75% reduction. And the highest strike rate since 1993 has been just 52. I think there are several reasons for the decline. And the first is that, as you can see here, union membership has been on a decline, and that trend roughly maps with the downward trend of industrial disputes. And so the first thing is obviously trade union membership. It used to be 50% roughly 50% in the 1970s, and it's now 18% and even lower in the private sector. But oddly, the most important reason for the decline has been the introduction of protected industrial action. Now, protected action is essentially a legal right to strike, and it was brought in by Keating in 1993. It was not a universal right to strike, though. The reason it's been so successful is that the right to strike has been closely regulated. It was already narrow when it was brought in, and successive reforms have narrowed it even further. So Keating's reforms in 1993 made it possible to strike, but only during negotiations for a new registered enterprise agreement. Howard then restricted this right in 2005 with work choices by outlawing patent bargaining, and he also required strike action to go through a secret ballot of employees beforehand. There was also an extensive list of prohibited content that you weren't allowed to strike on. And the Fair Work Act has kept most of the work choices changes intact. Patent bargaining is still illegal, you still need secret ballots, and there is still a long list of unlawful terms that you can't strike over. I should mention, though, that this list is a little bit smaller than work choices. So on the whole, industrial action has been one of the positive stories. Stories we hear in the media about skyrocketing industrial disputes. We had a slight kick up in disputes late last year. If we have a look right towards the end, there's a small kick up here. That's what all the fuss is about. That little kick up there. It's gone back down afterwards. As you can see, the industrial action is at record lows, and since the rules haven't changed a hell of a lot, I would expect them to stay that way. So to sum up, I think industrial relations debate has generated some overheated statements. While there are very real problems with the Fair Work Act, parts of it, I don't think the reform clock has been wound back to the pre-reform days. Australia's industrial relations system today is markedly different from what it was 20 years ago. Today, the majority of workers have their pay and conditions set by collective and individual agreements, and they are subject to market forces. This has given the workforce greater flexibility, higher productivity, better wages, and much higher than were available under the award framework, as we saw before. Also, reforms have narrowed and restricted industrial action, and those have largely been maintained. So as a result, workplace disputes are at historic lows. On the other hand, changes to unfair dismissal laws have, I think, opened the floodgates, and claims have skyrocketed. The costs created from an unfair dismissal claim, whether it's successful or not, will continue to wreak havoc on small businesses. The new good faith bargaining obligations have altered the balance of power between unions and employers at the expense of freedom of contract. I think it's still early days in the Fair Work Act, so watching the impact of good faith bargaining will be where the action is in the industrial relations space. But already, more and more businesses are complaining about a lack of control over management decisions and increased regulation of the bargaining process. So looking ahead, future labour market reforms are incredibly important. However, anyone who's expecting large improvements to productivity, like the ones we saw in the mid to late 90s, I think they'll be a little bit disappointed. Much of the productivity gains from industrial reform were achieved by replacing wage arbitration with enterprise bargaining. So instead, I think reforms can create value by increasing flexibility. Eliminating our archaic award system is a good start, and reforms to unfair dismissals and bargaining obligations will give businesses the freedom they need to generate wealth and create jobs. So that's all I've got to talk about today. So if I could open it up to questions.